Welcome to U.S. Immigration TV. Back in 2014, former President Obama issued a memo for Deferred Action for Parents of Americans, or Dapa. This was similar to the DACA program, Deferred Action for Childhood Arrivals, and the Dapa program would have allowed work authorization and protection from deportation for parents of U.S. citizen or lawful permanent resident green card holder children. Unfortunately, in 2014, court injunctions blocked DAPA from going into effect. DACA still is in effect. DAPA never went into effect. Well, there were many parents who had U.S. citizen or LPR, lawful permanent resident children, and were at first very excited when DAPA was announced. But then, of course, they got depressed when the courts blocked it from going into effect. This video is a wake-up call to DAPA parents or other parents who have U.S. citizen or lawful permanent resident children. Perhaps your U.S. citizen child was young at the time DAPA was introduced, but now, many years later, is over 21 years of age. Or maybe your green card or lawful permanent resident child is already a U.S. citizen and over 21. In that case, your child could possibly petition you for a green card, provided you are otherwise eligible and have no issues concerning your immigration status or eligibility, and also depending on the way you entered the U.S. Now, I have had many consultations after DAPA where I've advised people to come back when their child, their U.S. citizen child, turned 21, as that may have been the only avenue for them for legalization. And I think the record for me, honestly, about giving that type of advice was when a woman consulted with me at a time when she was only 5 months pregnant. And I just made a joke and I said, you know what, come back when the baby is 21 years of age. Well, you know what? Decades later, she showed up with her child and he was able to petition her for a green card. Now, in many cases, a person being petitioned by a U.S. citizen child could be eligible for their green card in the U.S. They don't have to depart the U.S. and apply at the U.S. Embassy, even if they are out of status, worked without authorization, etc. On the other hand, there are certain people who may not be eligible to adjust their status or obtain their green card in the U.S., depending on how they originally entered the U.S. Now, other parents may have fraud on their record, which could also affect their ability to get a green card through their U.S. citizen child. Now, if your U.S. citizen child is now over 21 years of age, you may want to consult with an attorney who could evaluate your eligibility and current immigration situation and perhaps assist you in pursuing your American dream. There could be ways around, even if you have fraud, there could be ways around that. Also, a lot of times, even if your child is still in school, they're 21, they're not working, they would have to submit an affidavit of support, but there are still ways that you can satisfy the public charge requirement, even if your child is not working. So if this applies to you, whether you are one of those disappointed DAPA parents who had applied or were eligible, or whether you now have a U.S. citizen child, whether they're 21 years of age or they were green card holders, now they're naturalized, you should consult with an attorney. This is a wake-up call because it's probably, if you are eligible, a heck of a lot better than waiting for an amnesty. I hope you have found this video informative. I will continue posting videos which I hope you find informative and helpful to you or to someone you know. Therefore, make sure that you like, share, and most importantly, hit that subscribe button so I know you're out there. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.